1st of May, all tenancies are going to be moving to periodic tenancies. Section 21 notices are going to be abolished, and there will be wider grounds for tenancies to be ended. A landlord is not able to withhold the right for a tenant to have a pet unless there are specific reasonable grounds. One of my anxieties is that for self-managed landlords, it really is a minefield in terms of making sure that they do comply. Welcome to the All Things Property podcast with me, Simon Bacon of Preferential Properties. Every week, Ian Sadler and I will delve into all things property. We'll guide you through with friendly, no-nonsense advice. Welcome to the All Things Property podcast with me, Simon Bacon.
And me, Ian Sadler from Aspire Property.
And today we also welcome, although I'm not sure how much he will participate, Ted from Preferential Properties. Morning, Ian.
Morning, Simon.
How are you?
I'm good, thank you.
Good. Yeah, not too bad, thank you. So today, Ian, we're going to talk about the Renters' Right Act, or as I sometimes call it, the Writers' Rent Act. But it's not. It is actually the Renters' Right Act. So we've talked about this before on previous podcasts. What's your understanding, would you say at the moment, of what tenants and landlords actually know about this?
I think the majority of them will need to be educated. The tenants, yeah, definitely. Tenants I've spoken to in the past 2 or 3 months, I've just not been aware of it.
Is that
landlord more
tenants, or is that
existing tenants, view tenants?
Yeah,
all sorts.
Yeah, I think from my perspective, it seems that when I'm doing viewings, quite a few tenants are know that there is something. They probably even know what it's called, but actually what it means, they're not that sure about.
I think they'd be happy to know. It favours tenants, doesn't it?
Yeah.
It makes life a lot easier from an
Absolutely.
occupancy perspective.
I do worry about landlords and what they actually know and understand about it. So hopefully we can try and just put a little bit of flesh on the bones for landlords, so they are aware of it. And if you are a self-managing landlord and need some extra advice, then probably worthwhile giving us a call to see what we can do to help. So let's get into it then. So Ian, what in terms of your landlords, how many of your landlords have actually contacted you and said, Ian, what is it that's we need to be aware of?
Very few.
Why do you think that is?
Because they're used to having their hands held through any changing administrative processes in the private rented sector, which I do. One specific landlord has inquired about the implications of the act on him as a landlord. Tenants, I have had one inquiry from a tenant. I'm sure they're vaguely aware of what's happening. But the rental market's in a state of flux, isn't it? Massively, legislation and changes of renters' rights and so on.
Yeah, it is, but
it'll take a time to get. It's going to take a long time to settle down.
Yeah, it will do. But in terms of, are you surprised then that landlords and tenants really aren't
very
well
surprised?
They're not, are they?
Oh, they're not.
I think the difficulty. I suppose it's interesting. There's all this talk about it now, but I don't have many landlords who come to me and go, just recap for me, what is it that is going on in May? Are we not communicating?
Your average professional and the landlords are not aware of how high this should be on their priority list. People lead busy lives, and it's not in focus at the moment. It will be, and I hope really hope it doesn't become highlighted to them by some terrible mistake they've made, or something's happened that's led to not being able to get possession of the property and the right notice hasn't been served.
But you can't, you talk about how hand holding landlords, and I think as letting agents that manage properties on behalf of landlords, it's something I'm very aware of is, we try really hard to make sure that all our landlords know. We're doing podcasts for that very effect. We send out emails to that effect. But, do you think landlords really take that on board? Do you think...
Well, we have to make them. At the end of the day, if a mistake is made by a landlord with a property that we're managing, then it's going to increase our workload no end. So we have a vested interest in letting them know exactly what's happening, leaving ourselves completely...
Because I found,
safe.
with the selective licensing in Birmingham, that, I notified all landlords about the selective licensing, but there weren't, I had landlords who are in the selective licensing area. So these are, and I'm talking about non-managed landlords now, because I wrote out to everybody saying, selective licensing is in force and these are the wards and this is what you need to do. But I still found that there were let-only landlords who didn't go down that road and didn't, just thought, well,
you can only do so much, can't you? You cannot get a fail-safe, perfect system of letting people know exactly what's going to be happening to them, tenants and landlords. But all you can do is be professional, just do as much as you can and limit the extra workload problems might cause for you and I.
Yeah. And do you think tenants are interested in having the information?
They'd be interested if something happens that makes them interested. Tenants looking for possession for a sale of property or moving back into it.
See, I think the biggest one will be notices. That if the notice, the notice period is extending for tenants, so it's going to 2 months, isn't it? So I wonder how many tenants will only really start to know that when they give their notice, still expecting impacts to be...
Do they not?
A month's notice.
How can that change? It's in most agents' tenancy agreements. Notice periods are required, isn't it?
Mm-hmm. But how many tenants? Do you ever get phone calls from tenants? I'm thinking of giving my notice. Can you tell me what notice period I need to give?
Well, that's normally a confirmation request, isn't it?
Well, no, I get quite a few tenancy phone ups saying,
I just don't know.
I'm thinking of handing my notice in. What notice period? And when you say to them, actually, your notice period runs from your rent due date. So if your rent due date is the 1st of the month, you need to have given us notice by the 30th or the 31st of the month of the previous month to then have that month's notice. A lot of tenants, I think, just think they give a month's notice from the date they give notice.
Yeah.
And that can be,
I don't see the understanding of it. The changes is going to change much, really.
No, I tend to agree with you, but I think, there is a, do we have an obligation to let them know that?
We as professionals we do, because we need to make as much effort as we can to make them aware, or as aware as we can do of the changes that are happening.
Yeah,
I guess if there are problems, it's going to reflect on us and it's going to give us more work.
Yeah, it's that partnership, isn't it? It's not just from a partnership with the landlord. It is a partnership to a certain extent with the tenant as well.
Well, that works both ways. You get a better relationship with the landlord because he appreciates you communicating with him.
Yeah.
And exactly the same with tenants. You have even if subliminal, you have a better relationship with a tenant. Yeah. And that tenancy.
The big thing about the Renters' Right Act was, I think for most people, was the abolition of Section 21, and that's certainly something that I think
benefits tenants.
Yeah, and I think quite a lot of people know about that. Less they know about, I think, is the fact that all tenancies are going to become periodic tenancies. But I think the thing that is still not really shouted about, not really identified, is the paperwork side of things and how that's going to work.
Yeah, why don't you explain the implications of that and what needs to be done from a tenant and landlord perspective?
Okay, thanks for that.
You're welcome.
So under the Renters' Right Act, landlords in the private rented sector, and that is all landlords, whether you are managed or self-managed, will be legally required to give tenants a written statement of key information about the tenancy before it starts. And this is going to take effect from the 1st of May 2026. For existing tenancies that are already in place, whether they're periodic or fixed-term tenancies at the current time, there is going to be a government information sheet which has to be given to all the tenants by the 31st of May 2026. So the government information sheet, the deadline for that is at the end of the month of May, even though the new legislation will apply to all tenancies from the 1st of May 2026.
And information that needs to be sent to landlords?
Sent to landlords? By landlords, you mean?
Well,
Or-
both.
Well, I think it's two things, really, isn't it? I guess we have got to notify landlords, certainly the landlords that we manage the portfolios of. We've got to notify them that we are going to be undertaking this exercise on their behalf and give them a little bit of clarity and support that we are going to make sure that they are compliant in terms of the information that has to go out.
So it's information based for the tenants and reassurance for landlords, really.
Yeah, absolutely. Yeah. I don't know what the tenants will think when they receive it, so we'll probably need to do a covering note so the tenants understand why they're getting it. Because what I often find, I don't know if you find it, I often find that when you send information out to tenants, around legislation type issues, it causes them a bit of concern. They're not sure why they're getting it. So probably needs to be a little bit of education to tenants, as much around what the changes are going to be to their tenancies.
Yeah.
So they understand that. Now the government information sheet, from my understanding, hasn't been produced yet. Due to be produced by the middle to end of March, I think.
Yeah.
That's my understanding anyway. So we should have a couple of months to get that out to them.
Well, I think that you've touched on the written information. It's a given that has to be served. It's a bit like the old prescribed information for the assured short hold tenancies that had to be served on tenants prior to the commencement of a tenancy. This is of equal importance.
Yeah. So do you know what's included in the written statements?
Well, as it hasn't been produced yet, no.
They've published some secondary legislation setting out what should be included. So let me just run through some of the things that have got to be included in the written statement. Landlord details, tenant details, so the full names of all the tenants, property address, the service address, i.e. an address where notices can be served on the landlord, rent details, amount of rent, when the rent's due, whether any bills are included in the rent, and any additional charges payable to the landlord. I know some landlords have utility costs included within the tenancy. Start date, notice periods, possession and rights. So a statement that landlord can only end the tenancy by obtaining a possession order. That's new. Statement of notice seeking possession must normally be served before court proceedings begin, and an explanation that possession notice periods vary depending on the ground used. They also need to include, blimey, quite a list, repair and safety obligations, a summary of the landlord's repairing obligations, confirmation the property must be fit for human habitation, additional legal obligations such as gas, electrical, safety checks, pets. Do you hear that, Ted? Pets. Information on tenants' rights to request keeping pets. So yeah, quite a list.
What does that change if a tenant has a right to request a tenant up and hug a pet? Landlord can still say no.
No, that's the change. A landlord is not able to withhold the right for a tenant to have a pet unless there are specific reasonable grounds.
That's woolly, isn't it?
It is woolly.
A bit like you, Ted.
Yes, very. So yeah, it is woolly, open to interpretation, I guess. So, I'm hoping that there will be some further clarity on that. We're already starting, when we get inquiries, people saying, well, is the landlord going to be accepting pets? And that's, try to accommodate as much as we can do. But I think for lots of landlords, that could well be a fundamental change in terms of pets, and how that's managed as well. But I think also what it will be really important to do is disclosure, full disclosure from tenants about, what pet, will there be a limit to the number, what kind of pet it is. For example, woolly pets like Ted maybe will have different issues as opposed to short-haired.
So do you envisage clauses being included in tenancy agreements, such as if you have a pet, you have an obligation to clean all the carpets and you're in a tenancy?
I think they will
It's
probably
only fair, really.
yeah, I think it is. But again, I guess I'm waiting for some clarity on that, clarity on whether or not pets have got to have vets. You've got to have details of the vet, whether you've got to have details that they are inoculated, all that sort of stuff, and flea treatments. It does open up a raft of things.
And how do you get the dog to or pet to sign a tenancy agreement? That's a big problem, isn't it?
Yeah, I don't think you will you, Ted? Nope. He doesn't want to sign the tenancy agreement.
For print, maybe?
Yes, he'll leave it to you to do it. So, yes. So, in terms of this, let's just recap, I guess, some of the stuff around the Renters' Right
Act.
Yes, actually, I've said it right. That's good. So all tenancies are going to be moving to, from the 1st of May, all tenancies are going to be moving to periodic tenancies. Section 21 notices are going to be abolished, and there will be wider grounds for tenancies to be ended, and more legislation around that. So yeah, there's quite a lot still to be done. Again, I think it's really important for all landlords, whether you're a managed landlord or a self-managed landlord, to start to really understand what your obligations are going to be. I think for managed landlords, we've started, I don't know what you've been doing, I know we've started communicating with them for some time now over the kind of changes that are coming out, to give them the clarity and understanding of it, and I suppose to support them that we're doing the right things. But I think my anxiety, I guess, one of my anxieties is that for self-managed landlords, it really is a minefield in terms of making sure that they do comply. And I can think of some of my let-only landlords who probably do need quite a bit of support around, what they've got to do and how they've got to do it.
The government have made available a really useful document, which is their interpretation of the Renters' Rights Bill.
Okay.
It's about a 40-page document, but it covers every aspect of all the changes, but some of them will be relevant to tenants, some bits won't. But
where would they get that?
On the government website, just if you Google Renters' Rights Bill, and it's a government information interpretation of the Renters' Rights Bill.
Dare I ask, is it in simple English, or
It is, yeah. Is it? Yeah, amazingly it is. It's really useful.
Do you think they're going to publish that I don't mean publish it, are they going to broadcast that? Is there going to be, do you know any advertising of these changes? Or?
No, I think you might find the government might think about doing some advertising closer to the date. I think maybe towards the end of March, beginning of April, just to cement people's views on what's happening. But that document's really, really useful.
Yeah. Okay. All right. So I guess it's probably worth us just summing up a little bit, and dare I say it, some calls to action as well. So to summarize, the main bit that I wanted to, I guess, get across from this particular podcast is the Renters' Right Act. The important thing is around the documentation. There are two, depending on what kind of tenancy, whether it's the existing tenancy or a new tenancy. So existing tenancies, all existing tenants will have to have the government information sheet provided to them by the 31st of May. All new tenancies must have a written statement or ensure that that written statement is included within the body of the tenancy agreement in order to make sure that you comply. And as with all government legislation, there are penalties for non-compliance, and I think off the top of my head the risk is fines of up to £7,000 for not doing it. So again, worthwhile making sure that you really are up to date. And for let-only landlords, again, if you are unclear and want some help or guidance, then please do get in touch. I hope you found this particular episode useful, and look forward to seeing you at the next episode. Thanks for tuning in to this week's episode of the All Things Property podcast. If you found this episode useful, don't forget to subscribe, like and share. These things really help us reach the people who need to hear this advice. See you next week.